Hi everyone, welcome to week 4 where we're looking at plain English drafting principles. Now here the key principle is to draft according to the purpose, context and reader, and we've already been through that in module 1, but plain English drafting goes beyond that. It looks at concise drafting principles, looks at the use of legalese and tries to reduce our reliance on legal terminology. So let's go into some of those details now. So the first thing I'd like to focus on is concise drafting. Long gone are the days of long-winded sentences. Lawyers used to be paid by the word, so it makes sense that documents were as long as humanly possible. But now we strive for concise drafting, clear and precise drafting that is expressed in a concise manner. So whenever drafting, stick to the motto, keep it simple. Now there are a variety of phrases that you use every day that can be reduced to a single word. So for example, I might say, with reference to X, really what that means is just regarding X or concerning X. So plain English drafting tells us that we should use that latter one word to symbolize what we're trying to say. So we'd start the sentence by saying regarding X. Another example is as a consequence of. We quite frequently say that when we're speaking. We quite frequently type it because we think it looks professional. But lawyers strive now for expressing content as simply and concisely as possible. So use something like because. Another thing to be mindful of is the use of superfluous words like hereinbefore, hereinafter, aforementioned, aforesaid, herewith. All of those phrases don't actually add anything to a sentence, so avoid their usage wherever possible. You'll find that they still pop up in the odd precedent. There are also a range of phrases, as well as just singular words, there's a range of phrases that don't really add anything either, like the parties hereby covenant and agree. Really just means the parties agree. So again, look out for those when you're reading older documents and precedents. Now, specialist legal terms are a tricky area. You really need to consider your audience here. Is it acceptable to use the phrase in personam when you're writing to another lawyer? Yes, it's acceptable, although in many cases a plain English equivalent does the job just as well. But it's important to use the plain English equivalent when you're writing to a client who will have no idea what that means and will be thoroughly confused. So when you're referring to legal terminology, when you're using legal terms and phrases, make sure that you have the reader in mind at all times. Moving on to looking at the difference between the active voice and the passive voice, plain English drafting principles say that we should use the active voice wherever possible. So look at the two examples on the slide and try to identify which one is expressed in the passive voice and which one is in the active voice. Pause the video if you need to. So the first example on the slide is an example of a sentence expressed in the passive voice. Here we have filed, which is the verb. The plaintiff is the subject because the plaintiff is the person filing the application, and the application is the object. That's the thing that's being filed. Here, the application comes first in the sentence, which means that the object appears first, then we have the verb, and then we have the subject. So that is expressed in the passive voice. So too is the sentence that follows, it was served on the defendant by the plaintiff this afternoon. In that sentence, the plaintiff is the subject, the verb is served, and the object is it, because it's the application that's being served. So here we've got it comes first, so the object is first, then it's verb, and then it's subject. Again, that's expressed in the passive voice. So if you look at this second example on the slide, that is an example of how those two sentences in example 1 can be rewritten to be expressed in the active voice. In this instance, both of those sentences within example 2 follow the subject, verb, object requirements. Now, why is this important? It's important because, of course, it makes the sentence longer and more difficult to work out. The reader has to wait till the end of the sentence to identify who is doing the action. Sometimes the use of the passive voice is unavoidable, where the person who is doing the particular thing, i.e. the verb, is unknown. So take, for example, a situation where someone comes home from work and finds that someone has broken into their house and stolen several items. You can see on the slide there, the witness might say, "When I went into the media room, I saw that the television had been stolen." Now, to steal, stolen is the verb in this situation. What's stolen? It's the TV. So that is actually the object. Usually you would identify the person, the subject of the sentence, who is stealing the relevant item, but because that person is unknown, then that person doesn't appear in the sentence. So this is perfectly fine, as we explored last week, but where the subject is known, then you want to avoid the use of the passive voice, because sometimes it can disguise who the subject is, or not even mention them at all. Moving on to gender neutral and non-discriminatory language. You may find when you're reading older statutes that traditional drafting is still employed in those texts, and they haven't been amended to correspond with contemporary drafting practices. So, for example, you may find that a statute only refers to the masculine. So, for example, if it's talking about an individual and what conduct that individual may do that amounts to an offence, it would only use he, him, and his when talking about the individual. That's archaic and should most definitely be avoided in your drafting. In such circumstances, you need to either use he or she, and of course the equivalents of his or her and him or her, depending on the context. Or alternatively, use they, and of course their and them. They is now the preferred way because it's more inclusive. You should also try and avoid stereotypes when drafting. You can see on the slide there the example of cleaning lady. Instead, you should use cleaner. What we're doing when we use things like cleaning lady is we're stereotyping and we're placing women usually in lower paid, lower skilled roles and males in positions of authority or higher paid roles. So sometimes we will see people refer to professor, doctor and judge as male even when they don't know the gender of the relevant person. And we see the reverse with childcare workers, cleaners and nurses. They tend to be assumed to be female. Where you don't know the gender of the relevant individual, it's better to use they, their and them, or alternatively he or she, his or her, him or her. There are a whole range of terms that adopt stereotypes and appear to be discriminatory when we look at them, so have a look at effective legal writing for more examples. It's important at all times to use inclusive language. An example is where you say X is disabled. Instead, say X has a disability. Why is that very small difference in expression important? Well, it means that we are not defining the individual by reference to that characteristic. And in a similar way, we should use respectful and culturally appropriate language. So, for example, when you're talking about Indigenous Australians, you should always use a capital I, which is a mark of respect. And you should also avoid using acronyms or slang that define groups or cultures or particular characteristics, because this can be taken by the reader to be both unprofessional and disrespectful. As effective legal writing explains, consistency in drafting is essential. Failure to be consistent may confuse the reader, and it can also lead to ambiguity in the interpretation of the document. So, for example, you should be consistent with your use of terms. Definitions can be very helpful, particularly in large documents. They can declutter the document and they can provide certainty as to what a word or a phrase means. However, if you're going to use definitions, make sure that you use that word consistently throughout. If suddenly a different word appears, the reader might assume that you meant something new. You're introducing a new term at this stage. Consistency of tone is also important. Now, the tone will be dictated by your client's instructions or the context, such as whether you are responding to allegations made in a letter you have received, or you're offering to settle the dispute in a letter to your opponent, and that will determine the tone. But you must make sure that you're consistent with that tone throughout the document to ensure that it has maximum effect. Grammatical consistency is also important, in particular in relation to the tense that you are using in that document. Issues with grammar look unprofessional, but they can also cause confusion in the reader. So make sure that your tense is consistent throughout, such as if you're speaking in the present tense about something in particular, such as your offer to settle, then make sure you maintain that tense for the whole of that aspect of the discussion. Consistency in presentation is also important. So your margins, whether you justify the text on the left or you fully justify it, your line spacing, the font that you use, the size of the font, and your paragraph numbering must all be consistent throughout the document. Things such as how you present the headings, whether you are putting them in bold or underlining them, whether they are larger than the text in the rest of the document, is also important. Your headings should be consistent. So if you have a primary heading and you use that in 3 places, that should all look consistent, and then your subheadings should be different to the primary heading, but they should all be consistent as well. Again, this is necessary to ensure that the document looks professional and to avoid confusion. Now, of course, if you're in legal practice and you're preparing a particular document and there's a practice direction about what format it should adopt, then you must, of course, ensure that your document is formatted in accordance with those requirements. The same is true if you have task instructions at law school that are quite specific about the format. Make sure that your formatting is consistent at all times. But if you don't have specific requirements, we recommend that you use a professional looking font like Times New Roman, Arial or Calibri, and that you use 12-point font size. And the reason we say that size of text is because it's very difficult for the reader to absorb information where the font size is smaller than that, and particularly when it's on a screen. So it's a really good idea to have 12 as the minimum. Use 1.5 line spacing and a decent margin on either side of the page to allow for some white space on the page, so that the words and lines don't just blur into each other when we look at the document on an A4 piece of paper or look at the document on a screen. The information can appear quite crammed, and it can be difficult to follow the sentence across several lines if it's small, densely packed in, and there's not enough white space on that page. Remember also that paragraphs symbolize that you're moving on to a new point or a related point, so make sure that you stick to 1 point per paragraph, and remember that headings flag to the reader what will follow, so your heading should very much symbolize what is about to follow in the subsequent paragraph. Note that it's not just the fact that headings flag to the reader what will follow that makes them really helpful in legal practice. If you've got a time-poor reader like a judge or an opponent, they can find what they need in a hurry. They can hone in on a particular aspect of the document and don't have to read it from start to end. You'll be pleased to know that this is the last week of covering the basics of drafting, and in particular legal drafting, and we're actually going to start applying what we've covered in modules 1 to 4 in a practical context. So from next week onwards, we will be looking at specific types of drafting, and our first area of focus is correspondence. We'll be looking at letters to clients and letters to your opponent and trying to apply the drafting principles to date and what we cover next week in the workshop next week. However, the workshop for this week is focused on plain English drafting, and you need to try and draft redraft a clause in a mortgage. Please remember to bring the draft with you. As ever, we will be working through our ideas as a group. I look forward to seeing you then.